G'day guys and welcome to this business management lesson. In today's lesson we're looking at key knowledge point 3.2.10. That is unit 3, area of study 2, and the 10th key knowledge point for this area of study. Today specifically we're looking at dispute resolution processes including mediation and arbitration. The dispute can arise in businesses for all sorts of reasons. Typically, however, dispute comes about when there are conditions or entitlements that need to be negotiated. It's often the case that what employees want and what an employer wants aren't exactly in sync, and where money is involved in decision making, people's greed, people's fear, people's insecurities can flare up, and dispute can arise as a response. Certainly, when negotiating a new agreement, agreements were covered in the last lesson, or where someone's job security might be on the line, where there's disagreement about managerial policies, certainly in the case where a management style like autocratic management or persuasive management is being implemented, if employees are disaffected, perhaps they feel taken for granted, or they just feel a bit abused, maligned in some way, dispute can arise there. Whether there are discipline issues that managers need to take care of, if they need to take corrective action to address behavior from their employees, perhaps disputes can arise there. Where there are health and safety issues, certainly employees who feel that their safety is at threat are likely to respond more defensively with regards to those issues than issues that don't affect their safety and well-being. And certainly, if there are any incidences of harassment or bullying in the business, you can imagine that that's likely going to be a symptom of a dispute between two internal stakeholders. As far as dispute resolution is concerned, dispute resolution processes are implemented to try and restore and maintain good relationships between internal stakeholders, so between employees themselves or between the employer and the employees. Where dispute exists, it can be a real source of demotivation for employees. Nobody likes feeling threatened. Nobody likes feeling harassed. Nobody likes feeling devalued. And dispute has that impact on people. Certainly, for businesses, if the dispute is between the employer and the employees, it's quite possible that even the operations of the business, the productivity and efficiency of the business would be compromised if the progression of the dispute led to industrial action. So dispute resolution is important, not just for helping your employees feel valued, but for ensuring that the business can continue to work towards achieving its objectives. If industrial action is taken, and we'll talk about industrial action in a second, but if your employees walk off the job because there's a dispute that just isn't getting resolved, that's going to be significantly damaging to your ability to achieve your business objectives. Common industrial action includes things like strikes, where employees might walk off the job site and stop doing their job for a time. Perhaps work to rule, where employees might start limiting their performance to their job description. They might not do anything extra, anything above and beyond to support the business in ways that they might otherwise do. Stop works or stop work meetings are also common, where employees might down their tools and they might stop working to have a meeting about the dispute that's going on or about the negotiations that are going on for a period of time. And certainly employers can instigate their own industrial action. They could issue or implement a lockout where the business is closed to prevent the employees from coming to work at all, and maybe employees' wages are compromised by a lockout. Typically, you'd see a lockout perhaps in response to these other types of industrial action. But what's important to understand is the days in which employees and employers could just implement industrial action willy-nilly are long gone. And these days, the Fair Work Commission is heavily involved in the approval or the rejection of applications to take industrial action. For the Fair Work Commission to approve industrial action, there are a few things that need to happen. There needs to be a current bargaining period in place. So typically, industrial action is only going to be approved where the employees and the employer are meeting to negotiate about a new agreement or negotiate about wages or conditions of work, something needs to be on the table for the Fair Work Commission to think that industrial action is necessary and approved. Certainly, there has to be an agreement that has passed its expiry. So if you're asking for a pay rise, but you're currently in the term of an active enterprise agreement, then the Fair Work Commission will probably reject your application for industrial action, because right now, if there's an active enterprise agreement, the negotiations that you're having are hypothetical anyway. They couldn't come in, any resolutions you came to couldn't come into effect until the existing agreement has met its expiry, and then you could be negotiating to implement a new agreement. So the Fair Work Commission won't approve any industrial action applied for during the terms of an active agreement. There needs to be demonstration that the parties involved in the dispute have genuinely made an effort to reach some sort of agreement before you apply to the Fair Work Commission for permission to go on strike. You need to be able to show that you have tried to come to a consensus. Certainly, the people who would be taking the industrial action need to vote in favour of the industrial action. So if you're looking to arrange a strike, the staff who would strike need to vote by ballot to approve, to demonstrate their preference to engage in this industrial action. And certainly an employer needs to be given notice that the employees, in many cases, intend to strike or engage in some other form of industrial action. The reason that the Fair Work Commission have these requirements is because in the olden days, in the Wild West, employees used to be able to just decide to strike. Perhaps an employer did something they didn't like in the morning, and by midday they'd walked off the job site and they weren't working in the employer's best interests anymore. And it created a bit of an imbalance of power where many employers, particularly in small and medium-sized businesses, felt a bit hamstrung by their employees. And it was employers and employer associations who lobbied the government to get these changes made in Australia to give employers some semblance of control and power in these scenarios. The consequence for engaging in what's called unprotected action, if it's not approved by the Fair Work Commission, can be that the organisers of the industrial action can be penalised and can be sued for damages by the business owner for loss of productivity. And certainly the Fair Work Commission themselves might issue penalties as well. So it's not sort of something you want to be doing willy-nilly. Now, when it comes to dispute in business, the first port of call should be a grievance procedure. Every business is going to have one. Typically, there'll be individuals within the business who you can go to raise your concerns. That might be your direct superior. It might be their direct superior. It might be a finance manager. It might be the manager of a different department, whoever it is. Typically, the business will identify different people that you can go to with a concern, and they'll have a flow chart like the one you can see on your screen, a procedure for talking through your problems, discussing your grievances, and coming to a consensus if one can be reached. Every business is going to have their own policy, so it's going to change from context to context. But what's important to understand, and what we saw from question 4A on the 2022 exam, is it's really important that you understand that a grievance procedure should be your first port of call. Where you have a dispute in business, you as an employee should make an effort to discuss this grievance with your manager and try to come to a consensus that way. As the manager, you should be approachable and prepared to hear concerns and grievances where they occur, and you should have a process in your business to help your employees come to a consensus. So that might include informal or formal discussions. It might include meetings. It might include a dispute resolution process. We can't get much more specific because we're not talking about any specific business. But generally speaking, meetings and a dispute resolution process should be the first efforts made to resolve a dispute. But if that doesn't work, well, we can try mediation. Mediation is where a third party facilitates discussion between the disputing parties. So let's say you represent the employees in your business and your agreement has come to its expiry, so you're due to negotiate a new one, and you're asking for increased wages for the employees in the business, and the employer is not interested in hearing it. They're being quite difficult, and you're not prepared to back down from your request. You think it's a reasonable request, so you're going to keep making it, and they're not prepared to have a conversation about that. Negotiations are probably quite quickly going to come to a stalemate, where you're going to keep asking, and they're going to keep saying, ask for something else. We're not having that conversation. And it might be that the negotiations cannot proceed because you're both being difficult and neither of you is prepared to engage in the best interests of driving the negotiations forward. So you might have a third party come to the table as a mediator. They would facilitate the discussion. That might include them setting the agenda. That might include them making you take turns to contribute to the conversation. That might include the mediator stopping someone when they're getting rude and saying, that's not how we talk to each other. You've probably in your life, if you can think back to your experience of primary school, had an example of mediation from a primary school teacher. It's what we all needed when we were learning how to be civil. And in business, well, sometimes it's necessary. What will happen? The role of the mediator is an official one. It's a position that the Fair Work Commission recognises as a position of authority. The mediator will help the two parties come to an agreement, but the mediator is not influencing the agreement. This might not be enough. Perhaps these parties can be forced to or facilitated to have a conversation. Mediation might be successful, but a solution might not be found. Maybe a consensus is not reached, in which case you might use arbitration. This is where an independent third party acts as the tribunal. They act as the judge. Each of the negotiating parties makes their case to the arbitrator, who then thinks about it, goes away, considers the arguments being made, and makes a final decision on behalf of the parties. Now, the process of arbitration is legally binding. If you enter into the process of arbitration, whatever the arbitrator decides, you've got to be prepared to live with it. So it's important that you choose an arbitrator who you trust, and this is where the Fair Work Commission can come in. The Fair Work Commission quite commonly act as the independent tribunal for arbitration for businesses in their negotiation periods, when they're negotiating agreements. That is one of the roles of the Fair Work Commission, and it's something they do well and reliably. In summary for this key knowledge point, where disputes arise in business, productivity and efficiency can be negatively impacted. We know that a dispute can have a really negative impact on engagement and motivation for employees, and we know that engaged and motivated employees are more productive and efficient, so you can understand that if engagement and motivation takes a hit, the productivity and efficiency of your labor is also going to decrease. So to maintain high productivity and efficiency, it's important to resolve disputes quickly when they arise. If possible, a dispute resolution process or a grievance policy should be followed as a first attempt. However, in not all cases is that going to be successful, and if it's not, you might move on to mediation or arbitration, which are both processes named in this key knowledge point, so you need to be familiar with them. That's all for today. See you next time.